Going to start now. Today is 258th Friday group meeting. The topic is propelling trade and commerce through the Constitution. The speaker is our beloved friend, Mr. Nakul Dewan, Senior Advocate and King's Counsel. We are highly grateful to you, Mr. Nakulji. You immediately accepted our invitation. We are so nice of you, and I'll recently appointed King's Counsel also. We want to know what exactly King Counsel and other things, whatever, in 1 or 2 minutes before beginning itself. Sure. This is 45 minutes your speech plus minus whatever it is. Any question answer we will listen, and finally cup of tea subject to your matter and other things. Sure. Okay. Then before that, this is we published recently. This is 75 years of Constitution and lawyers role in India's freedom.
Thank you very much.
This Gawai has released this book, Narasimha and Vishwanathan and also.
No, thank you very much. Thank you so much.
Yes, Soumya, one of our young members, will read Sir's CV. Please, Soumya, please, sir.
It is my privilege to introduce Mr. Nakul Dewan, Senior Advocate and King's Counsel, a legal professional whose expertise span multiple jurisdictions and area of law. Mr. Dewan holds a B.Com Honours from Sri Ram College of Commerce, University of Delhi, Bachelors of Law from Faculty of Law, University of Delhi. So further pursued Masters of Law from New York University and National University of Singapore. Admitted to practice in India in 2001, Singapore in 2010 and England and Wales in 2014. Sir was designated Senior Advocate by Supreme Court of India in 2019, one of the youngest to receive this honour. He is also appointed a King's Counsel in UK, appointed in the year 2025. With over 2 decades of expertise, Mr. Dewan has represented clients in high-profile cases across various sectors. He has appeared before courts and arbitral tribunal in India, Singapore and UK. Appointed as arbitrator in the institutions such as Singapore International Arbitration Centre, International Chamber of Commerce, London Court of International Arbitration. In addition to this, Sir has served as an adjunct associate professor at the University of Singapore. Served on the advisory board of the Yung Pung House School of Law at the Singapore Management University. Sir is chief editor and contributor of the book Enforcing Arbitral Award in India. Please join me in welcoming Mr. Nakul Dewan, Senior Advocate. Thank you, sir.
Thank you so much. So nice of you. Nicely explained. Before Nakul, you just explain what exactly the King Counsel and other few things. So before you start, we want to know from you.
Yes. Let me first begin by thanking you, sir, for inviting me for this Friday lecture. I have certainly heard a lot about this lecture, but what I hadn't appreciated was that it is the 258th meeting. That is very, very significant because, we start a lot of things with a lot of earnest at the bar. A lot of them just fitter away in time. But given the fact that you've done this for close to a decade, it clearly goes to show the commitment that members of the bar have for this Friday group. So I am deeply honored and privileged to have been invited today. And I must tell you that I looked at some of the YouTube videos that were there. I looked at some of the other profiles. And honestly, some of the senior most and some of the most revered members of the bar have had the privilege of speaking here. So I am deeply grateful for this invitation. Anyway, coming back, I hadn't thought I would begin this by talking about what King's Counsel meant. That certainly wasn't what I had in mind. What I had in mind was not a lot of the arbitration or the international practice that I do, but what I had in mind was really grassroots constitutional law and how our courts and our constitution has actually impacted commercialization of the country. In many ways, the way trade and commerce has progressed through the years because of the constitution and because of courts. But let me spend 1 minute on what King's Counsel means. King's Counsel is the equivalent of the designation that you get in India as Senior Advocate. It is conferred by the United Kingdom and it is conferred through a process which I wouldn't say is similar to what we have here, but certainly a very rigorous process based on the cases that you do. So that's really what it is. And yes, I had the cases to make the application. I made the application, and God was kind, and I made it. But that's really what it is. Now, I'm going to come back now to to the speech that I had prepared, and I can certainly tell you that given all the stalwarts who've addressed you in the past, I cannot certainly have professed to have the same level of knowledge which those people have had. But that notwithstanding, let me at least make a start somewhere. Now, all of us are aware that the Constitution of India is the grand norm, right? It is actually the blueprint for both our legal as well as our political system. It's a charter of individual rights, and it's actually a basis for overseeing how the state functions through the three separate wings, the executive, the legislature, and the judiciary. But when you think of the Constitution, very few of us think about it as being a commercial document. And while it certainly isn't a commercial document, it has within itself an entire section, and that's in part 13, in relation to trade and commerce. So, what I am going to do today is actually divide my lecture into three different sub-facets. And to do that, I am going to first give you a broad overview so that we have a sense of where I'm going to be taking every bit of my lecture to. Now, it's very important also for us to remember as a background fact that more often than not, courts in India have taken the view that as far as economic policy is concerned, they will stay away. And that is because the judiciary is not well versed with economics, and certainly will take what I would say the correct view to say we will not interfere with economic policy. But what you see in reality is how the courts have actually stepped in at the right moments of time to protect economic policy, and in fact to give rights to people and recognize rights under our constitution which actually ensure freedom of trade and commerce. So I am actually going to begin with a quote from an author. He's a famous constitutional author on Indian law. His name is George H. Gadbois. He wrote a book called The Supreme Court of India, The Beginnings. It was released in 2017. And what he says is the following. He says the jurisdiction of the Indian Supreme Court is so wide that it will appear to be one of the most potent judicial organs in the world today. But what he observes after that is extremely telling. And what he says, and let me quote again, he says, in fact, the courts in India have enjoyed a vast amount of prestige and confidence amongst the public. The high courts, some dating back nearly a century prior to independence, and the federal courts had established an enviable record of integrity and independence. Thus, when it came to deciding upon the jurisdiction of India's Supreme Tribunal, endowing it with extensive jurisdiction was seen by most as both wise and desirable. And that is extremely important, and I certainly will absolutely agree with that observation, because when you juxtapose the role the court has played in relation to protecting trade and commerce, you will see the firm hand that it has maintained in order to ensure that certain principles such as fairness and equality are in fact retained. So, bearing in mind that the Supreme Court is the sheet anchor for India's democracy as well as for its economic polity, what are the three heads that I'm going to cover today? In the first part, I am going to touch upon part 13 and the freedom of trade throughout India. In the second part of my lecture, which I actually, when I was writing it, found to be the most exciting, I will actually address you on certain aspects such as Article 19(1)(g) and Article 14, which reflect some of the challenges that have been raised before the Indian Supreme Court in relation to commercial cases. And in the third part, I am going to address you in relation to the government's role in commerce through government contracts and the distribution of natural resources. So let's move to the first part, which relates to the freedom of trade throughout India. Now, all of us know that Part 13 of the Indian Constitution comprises of a series of articles which go from Articles 301 to 307, and it deals with trade, commerce and intercourse within the territory of India. Now, you may wonder why my starting point is going to be an article which is now, in some ways, a little defunct. Because Article 301 to 304 has resulted in a lot of litigation right from the 1960s all the way till close to 2020, sometime in 2022, related to a concept called entry tax. And today nobody looks at entry tax because you're now part of the GST regime. But the reason why I bring that out is to show you the approach the court followed, because as Martin Luther King once said, he said, "We're not makers of history, we are made by history." And that's the philosophy that I want to show you, to be able to demonstrate how the Supreme Court of India has actually looked at supporting trade and commerce throughout the length and breadth of this country. So the historical background in my view is actually relevant, and let me just begin that by quoting what 301 sets out, though I think a lot of you will anyway know it from the back of your hands. 301 says freedom of trade and commerce and intercourse, and it says subject to the other provisions of this part, trade, commerce and intercourse throughout the territory of India shall be free. Now, it's extremely important to remember that this was borrowed from the Australian Constitution. But there was one big difference between the Australian Constitution's formation and the Indian Constitution's formation. And that was in fact noted by Justice Hidayatullah in one of the decisions early on. But the point that I want to make here is the following. When India got independence, there were a lot of princely states. And every princely state literally was run in its own fiefdom and had to have its trade and commerce to support itself. And you had to have a constitution which was looking at uniting all of these princely states into what we all know is the quasi-federal constitution. So Article 301 came in with the freedom which set out that subject to the other provisions of this part, trade, commerce and intercourse throughout the territory of India shall be free. But all of us know that no freedom is ever absolute, and certainly Articles 302 to 304 imposed certain restrictions which in fact allowed Parliament and state legislatures to pass laws. And as I said, the best example that I have seen of this has been the entry tax concept. So what is entry tax, right? If you go back to what is now an obliterated article from list 2 of the 7th schedule, you will realize that it's article 50, it's entry 52. And entry 52 of the 7th schedule allowed the imposition of entry tax on goods into one state. And how that got protected was because of Article 304 sub A. And let me just read that out to you briefly. And it said, notwithstanding anything in Article 301, the legislature of a state may by law impose on goods imported from other states or union territories a tax to which similar goods manufactured or produced in that state are subject, so however as to not discriminate between goods so imported and goods so manufactured. So let me just put this out as an example, right? So if you were to say take the case of, say, I mean, this is purely a hypothetical example. Take the case of, say, a manufacturing industry, right? And let's assume that the state of Tamil Nadu said for the manufacture of shoes, we will give you certain waivers. So certainly manufacturing shoes in Tamil Nadu would become cheaper than it would in, say, another state. If you brought shoes in from Tamil Nadu to the other state, certainly it would have an impact on the other state because you could certainly go and sell it cheaper. And what entry tax did is that it allowed the other state to impose a tax on the entry of those goods so as to equalize the position and ensure that parity was maintained. Now, the first time a provision such as this got challenged, it actually got struck down. And that's very interesting because the view that was taken by a 5-judge bench in 1961 comes from a case called Atyabari. And in Atyabari, which subsequently got partially overruled, and I'll come to that in a bit, I found a very profound statement by Justice Gajendra Gadkar. And it's profound because it has an impact even as of today, and I will certainly come back to that in a bit. But Justice Gajendra Gadkar said the following. He said, free movement and exchange of goods throughout the territory of India is essential for the economy of the nation and for sustaining and improving living standards of the country. The provision contained in Article 301, guaranteeing the freedom of trade, commerce and intercourse, is not a declaration of mere platitude or the expression of a pious hope of declaratory character. It's also not a mere statement of a directive principle of state policy. It embodies and enshrines a principle of paramount importance that the economic unity of the country will provide the main sustaining force for the stability and progress of the political and cultural unity of the country. Let me repeat the last sentence again. I think it is so profound and it has such an important impact even in today's day and age. He said it embodies and enshrines a principle of paramount importance that the economic unity of the country will provide the main sustaining force for the stability and progress of the political and cultural unity of the country. Now, while Atyabari got partially overruled 6 months later by a decision in automobile transport, it got overruled on the point that if the state imposed a tax, then certainly that taxing provision would be permissible because and brought in a concept of compensatory taxes. Now I don't need to go into all of this because finally all of this came down to be reconsidered by a 9-judge bench in 2017 in Jindal Steel, which laid down 9 Averwed principles. Let me just focus on 3 of those principles today. What the court said was this. One principle that they brought out was that a tax on the entry of goods into a local area for use, sale or consumption is permissible. 2, they said, Article 304A frowns upon discrimination of a hostile nature in the protectionist sense and not on mere differentiation. Therefore, incentives, set-offs granted to a specific class of dealers for a limited period of time in a non-hostile fashion with a view to developing economically backward areas would not violate Article 304A. And 3, they said, states are well within their right to design their fiscal legislations to ensure that the tax burden on the goods imported from other states and goods produced within the state fall equally. Such measures would not contravene Article 304A. Now, if you look at the entire gamut of case law surrounding 301 to 304, the 3 decisions of the Supreme Court of India, 5-judge bench in Atyabari, the 7-judge in automobiles and the 9-judge in Jindal Steel, what do you get? What you get is an extremely important principle. And the principle that emerges is that you will allow trade and commerce to flourish in every state in India. And it's a recognition that not all states in India are at an equal stage of development, and if fiscal measures are undertaken by a state to propel their own financial progress, then such measures would be permitted so long as they are non-discriminatory. And that is why the entire Part 13 and the judgments of the Supreme Court over a period of 50 years have ensured that there has been progress and development in every state. So if a state brings about a provision which exempts industries from taxation because it's in a remote area and imposes certain taxes because it wants its own industry to flourish, as long as it's non-discriminatory, that's going to be permitted. And that is the growth that you see all over India. Now, is all of this really lost because of the GST regime? Well, the answer is actually exactly the opposite. Because when you have these kind of provisions and you have this kind of permissibility, it allows you to set up the backdrop for the GST regime. Now we all know that the GST regime came about on the basis of a constitutional amendment, and this was a constitutional amendment which brought about Article 246 capital A, which gave Parliament the exclusive power to make laws with respect to goods and service taxes where the supply of goods or services or both takes place in the course of interstate trade or commerce. So that entire regime went to Parliament. Certainly, as most laws are, significant parts of the GST regime were also challenged constitutionally, which included the mandate of the GST Council, the powers they had. But there's one very important decision which I came across, which is a 2022 decision, which I thought would be very relevant for the purposes of today's lecture. And this is a decision of, it's titled the Union of India versus Mohit Minerals. It's a 3-judge bench decision of Justice Chandrachud, Justice Suryakant and Justice Vikramnath, where the issue was whether an Indian importer could be subject to the levy of GST on a component of ocean freight paid by a foreign seller to a foreign shipping company. And in that context, I found a very interesting observation of the court. And it was an observation on federalism. And what Justice Chandrachud noted was this, and he said, the dual federalism model or the autonomy model views the constituting units of the center and state as autonomous, independent and competing units. This model is also termed as competitive federalism, where the constituent units compete with each other. So even in the GST regime, the court has been conscious of the economic development of every state, bearing in mind that in many ways, from a commercial perspective, one state potentially competes with another for its own economic growth. And this philosophy again augurs well for the growth and development of India. We all know what the GST Council has to say about the advantages of GST. The GST Council says that GST is expected to lower the cost of goods and services and boost the economy and make our products and services globally competitive. GST will make India a common national market with uniform tax rates and procedures and removes the economic barriers, thereby paving the way for an integrated economy at a national level. Just hark back now to Justice Gajendra Gadkar's statement in 1961, which I've read out twice. In 1961, he spoke about how the Indian economy had to unite as one. In 2025, we follow the same philosophy. That's why I said it is such a profound statement made in 1961, when India was at a very, very different stage of its economic development. Let me now move on to part 2 of my lecture. Part 2 of my lecture deals with Articles 14 and Articles 19 and how those articles have in fact been utilized for the purposes of protecting trade and commerce. And what is extremely interesting when you go through some of the authorities is that these articles have in fact been utilized to go and protect what I would say are contemporary and progressive trends in trade and commerce by constitutionally affirming rights under Article 19(1)(g) as well as the equality principles under Article 14. And I am going to now leave the historical part of this development and focus on what we see in the current regime today. There are 3 areas of my focus under this head. The first, IBC. We see a lot of IBC cases coming up to the Supreme Court as of today. And what is extremely important when you look at the IBC is that, ironical as it may sound, the Insolvency and Bankruptcy Code and its proper functioning is extremely important for the growth of trade and commerce in the country. And the reason why it's extremely important is because having a well-working insolvency regime is very important for creditors, because creditors need certainty and creditors need control when they realize that their investments are going south. And that is what the IBC seeks to bring up. Now, all of us are aware one of the first few challenges to this court in relation to the constitutionality of the IBC was a decision in Swiss ribbons. What is so important about Swiss ribbons is that while courts have typically taken the view that they will not interfere with matters that are economic in nature, and they certainly didn't do so in Swiss ribbons, they considered the issue under Article 14. Because the argument that was made in Swiss ribbons was the following. The argument was that you could not treat a financial creditor any different from an operational creditor. Now we all know a financial creditor under the IBC is the one who gives money. An operational creditor is the one who provides goods and services and is required to be paid for it. And the argument was, how does it matter if the company which has now gone into CIRP, which is a corporate insolvency resolution process, has gone defunct, it owes us money. So we are all sitting in the position where we are owed money, and hence there must be some equality amongst all of us. And the court said no. That is not appropriate. And the reason why it's not appropriate is because you are looking at it the wrong way. There is a big difference between a financial creditor and an operational creditor, because a financial creditor is generally a secured lender. It has significantly greater exposure as compared to an operational creditor, and it must therefore be given additional rights under the IBC. And it did that because it recognizes that finance is the backbone of corporate India. And if an operational creditor and a financial creditor would be equated together, it would have certainly led to a collapse of the IBC. So it used Article 14 to set out that there was in fact a rational basis for the differentiation between an operational creditor and a financial creditor. And this was very similar to a view it had taken 10 years before, when the SARFACI and provisions under the SARFACI were challenged in a case called Mardia Chemicals, where the argument was you're giving the banks and lenders such extraordinary power that they can go and take away an asset even without having to go through an adjudicatory process. And the philosophy that this court followed in Mardia Chemicals was, but the bank and a financial lender is only taking that, exercising that right to take over your property because you are a defaulter. And as a defaulter, we're not going to give you an extra right to run through an adjudicatory process, because that will again effectively mean that lenders will not want to lend. And if they don't lend, the economy stagnates. The second case that I want to talk about under the IBC regime is actually the case of SR Steel, where all of us are fully aware that once SR Steel, which is one of the largest companies, went into IBC, the promoters did everything to try and ensure that the plan would fail. And they came to the Supreme Court with an extremely novel argument. They said the IBC makes a provision where 330 days has been set out for the purposes of going through a CIRP process. If the 330 days goes, bad luck, sorry, the process fails, that's the end of the process, you must turn the clock back. And the Supreme Court did something which it doesn't rarely do. It looked at its own judicial system and said the following. It said, no one can be faulted just because there are judicial delays. Where for no fault of either of the relevant parties, a case doesn't get heard. And on that basis, it took the view that having a mandatory 330-day provision was in fact violative of Article 14, because a right to equality was being denied for no fault of either of the relevant players, merely because a case got plugged in to a system which had delays. And the court in fact struck it down both under Article 14 and under Article 19 1G. And let me just read out some relevant parts of this. And the court said, a provision which mandatorily requires the CIRP to end by a certain date without any exception thereto may well be an excessive interference with a litigant's fundamental right to non-arbitrary treatment under Article 14, and an excessive, arbitrary and therefore unreasonable restriction on a litigant's fundamental right to carry out business under Article 19(1)(g) of the Constitution of India. And it said we will in fact go ahead, we would have ordinarily gone out and struck out the entire provision, but then that would mean that you were throwing the baby out with the bathwater. And so what it did is that it read it down by deleting the word mandatory from 330. And again, its reasoning becomes important, because it said, because any other decision would have sent the corporate debtor into liquidation, which is not the purpose of the Act, because the purpose of the Act was to ensure that a corporate debtor got rehabilitated. And if the corporate debtor got rehabilitated, you would ensure that the company was protected, and so were the employees, which would not be the case if the company went into liquidation. And again, very similarly, a couple of years later, the Supreme Court, again in a case called Ebix, did precisely that. It went into the IBC and said, well, it's part of the economic domain, and we are certainly not going to interfere beyond the point. But again, it had a very relevant observation, and it said, the procedure designed for the insolvency process is critical for allocating economic coordination between the parties who partake it and who are bound by the process. Now let's move away a little bit from IBC, which I know has engulfed courts over the last 8 to 10 years, and move into something which I find extremely interesting. And that is a case, I mean, part of the case that I have argued, but a concept which I still don't fully understand. It's called cryptocurrency. And I think a lot of us wonder what is cryptocurrency, but the fact of the matter is cryptocurrency is there and it's here to stay. Now, a lot of you may not be aware, but in 2018, the Reserve Bank of India actually came and banned cryptocurrency. And that was very surprising, because cryptocurrency came about in this world sometime, in 2000s. It was flourishing in India from 2015. Nobody said anything. There was no legislative embargo, and the RBI came and decided that it had to ban it. So what was extremely interesting was the nature of the RBI ban. And it was, if you think about how RBI crafted it, it was really interesting. RBI sent out a directive to all of its banks and said, you will not allow your banking channels to be utilized for the purposes of purchase and sale of cryptocurrency. So you have a lot of these cryptocurrency exchanges. Obviously, if you have like a stock exchange, you have a cryptocurrency exchange. And if you are going to buy and sell on a cryptocurrency exchange, you have to use banking channels. Nobody is going to take a bag of cash and say, you can't give a bag of cash to anybody. And cryptocurrency is intangible. You can't see it. So who are you going to give the bag of cash to? There's nobody to give it to. But effectively, that RBI ban resulted in there being zero trades in cryptocurrency. And again, people in our country decide, those who had to traded, they just traded outside of India. But the matter comes to the Supreme Court, and what the Supreme Court does is this. It certainly recognizes that the RBI has the power to regulate cryptocurrency, because cryptocurrency in many ways is a form of money. But what it then does is look at avowed and deep down constitutional principles on what are, effectively there are 4 constitutional principles that it looks at. The 4 principles are: 1. Did the ban have a designated legitimate purpose? 2. Was there a rational nexus between the ban and what was sought to be achieved? 3. Was there a less intrusive mechanism that could achieve the same objective, which was supposedly regulation? And 4. Did it balance the public purpose that was sought to be achieved, because you were effectively restricting a trade under 19(1)(g)? And in the end, it struck down the ban by taking the view that no, it was disproportionate. So while it recognized that the RBI had the power, the ban was struck down on the ground that it was disproportionate, and what was recognized was the right of trade and commerce under 19(1)(g). And because of that, what has happened is that cryptocurrency in India has now effectively been permitted to run through an absolutely legitimate method. Now, should it be regulated? I, who was a proponent of the ban the ban having to go, am of the view that yes, it should. Are there enough regulations? There perhaps are not. But regulation versus restriction is the issue. And if you regulate, you promote trade and commerce because you want things to happen in a fair and a regulated manner. If you restrict, then you effectively take away a particular manner of trading. This transcends into one other aspect, and it's actually social media. And all of us look at social media in very different ways. Some of us like it, some of us don't like it, some of us use it. But let's also remember that social media is effectively trade and commerce for a number of people. And social media and the new mediums for disseminating information have opened up the ability of people to speak out. So I'm now going to segue into a Bombay High Court judgment in the Kunal Kamra case, where what the Bombay High Court was grappling with was in fact a rule under the information technology rules. And in that case, the court was considering whether a rule that effectively imposed or mandated only social media platforms which are online to remove news content because they were potentially fake and did not impose the same restriction on print media could be said to be violated. And the court said, yes, in today's day and age, you cannot distinguish between social media and online news platforms versus print news. And if you must have a regulation, then it must apply across the board. And while that, I just want to read out one part of the decision. This is Justice Patel's view. On this, he said, social media has become the primary news medium for the last half decade or so. There is some material to show a decline in hard copy newspaper readership in India. That in turn means a stagnation or a decline in advertising revenue. Social media is thus the primary driver for news dissemination. The impugned rule targets social media content even from news outlets that have print media and about which nothing is or can be proposed. Thus, there is thus a direct infringement of 19(1)(g). And while this case is pending before the Supreme Court, please again appreciate how it is looking at the issue. It's looking at the issue from the perspective of your freedom to trade. Social media, as we are fully aware about, requires the advertisements to keep it alive because it's available literally free to everybody. And if you are going to impose restrictions on social media, which will then impose restrictions on advertisers, you're going to kill an industry. And there are hundreds and thousands of jobs that today depend on social media. And again, what you see effectively and this is why I said part 2 of my lecture I think is going to be the most exciting, because it really relates to real life, is how courts in today's day and age have followed the same philosophy that courts in the yesteryears followed, which is to ensure that our protections under Article 19(1)(g) and Article 14 are in fact not restricted in a manner that curtails trade and commerce and ensures that everybody has a level playing field. Let me now move on to the last part of today's lecture, and that is the constitutional power of judicial review. Now we all know that emanates from Articles 226 and Articles 32. But why and how does it impact trade and commerce? Well, it impacts trade and commerce because under Article 298, the state actually has a role to play in commerce. And we all know that, one of the reasons why the government is such a significant litigant is because the government controls a large part of trade and commerce. There are government contracts, there are tenders, there are natural resources which the government wants to exploit through private entities. And that's all part of India's liberalization and private ownership. But there are two very important facets that the courts have recognized while they have looked at these issues. The first is governmental freedom, and the second is governmental fairness, and they both literally go hand in hand. Now if you go back, and I'm sure again a lot of you will know this, but one of the first few cases which dealt with judicial review of in relation to tender matters and governmental contracts was the R.D. Shetty versus the Airport Authorities of India case. And that was in 1971, and there were a lot of judgments between 1971 to the early 1990s which literally vacillated on the degree of judicial review and the degree of judicial scrutiny, till we then came to a decision in Tata Chemicals which still holds the field on the standard to be applied for judicial review. What is extremely important is a very interesting statement in the Tata Cellular case. And that statement says the following. It says the government must have freedom of contract. In other words, a fair play in the joints is necessary, concomitant for an administrative body functioning in an administrative sphere or quasi-administrative sphere. However, the decisions must not only be tested by the application of the Wensbury principle of reasonableness, including its other facts pointed out, but must be free from arbitrariness. So, and that's the reason why I made the point on both freedom and fairness. Because if you take away the freedom from the government and you give them no play in the joints, then you are stifling trade and commerce. But if you give them the freedom, and as long as you ensure fairness, you are then ensuring that today trade and commerce progresses. And so the first point that I make is that freedom of contract is fundamental to the growth of commerce, and excessive judicial interference, even in the sphere of government contracts, would fetter such freedom. And that is what touches upon the second point, on the element of fairness. And the element of fairness, I think, is best made out, along with obviously the element of freedom, in two seminal decisions, one related to the 2G case, which relates to natural resources, and the second related to the coal block case. Now, all of us know that there was a 2-judge bench decision in the 2G case which had set aside a number of telecom licenses on the ground that there was no public auction. And that judgment, in fact, took the view that a public auction was mandatory for the purposes of allocation of any natural resources. Now, that was effectively dictating a procedure, which, in my view, was correctly set aside when a reference was made to 5 judges who took the view that you couldn't mandate a public auction. But while you couldn't mandate a public auction, you certainly had to ensure that there was fairness in the procedure. Which fairness doctrine got reaffirmed when the coal block cases came, and I quote from the decision where the Supreme Court said, "It is not the domain of the court to evaluate the advantages of competitive bidding vis-a-vis the other methods of distribution and disposal of natural resources. However, if the allocation of the subject coal block is inconsistent with Article 14 of the Constitution and the procedure that has been followed in such allocation is found to be unfair, unreasonable, discriminatory, non-transparent, capricious, or suffers from favoritism or nepotism and violative of the mandate of Article 14, the consequences of such unconstitutional or illegal allocation must follow." And that is how, in relation to government contracts, the courts have over the years blended in a beautifully crafted doctrine of freedom and fairness. So now let me just conclude my lecture for the day. And I'm going to come back to Gadbois, which I started off with. And it's interesting to note that while Gadbois accepts that in theory our constitutional courts have extensive power, he has taken the view that they're not necessarily always that powerful. And he gives a number of examples, one of which is that Parliament always has the power of vitiating a decision of the court by either amending the Constitution or even the statute. And I'm just going to take you back and hark back to an example of a case which I was involved with as a junior many years ago, and it relates to the 2011 Vodafone case, where I was acting as a junior to the then Solicitor General of India. And in that case, what the Supreme Court did was that it set aside a decision of the Bombay High Court and struck down an 11,000 crore levy on Vodafone, which was one of the largest, and I think in the history of India has been the largest tax reprieve that any company has received at the hands of the court. Well, what did the government do? The government certainly wasn't happy with the decision of the Supreme Court, so it proceeded to statutorily amend the Income Tax Act. And it did so by way of by way of an amendment which was retrospective in nature, which is well within the power of the Parliament. And I know for a fact, while I was on the other side, that Vodafone seriously contemplated making a constitutional challenge to the retrospective amendment. But it did not. And it did not because it found another avenue, and an avenue which allowed it to go outside of India. There is an entire concept called investment treaty arbitration. And an investment treaty arbitration effectively allows a party to sue the government of a state, or to effectively, let me rephrase that, to sue a state if it has taken any action which is either not fair or equitable, and there are certain other principles that come into play, on the basis of which an investment has been made into a country. And the investments that had been made into India were on the basis of an India-Netherlands treaty, and on that basis an action was commenced against the Republic of India. And the basis was that despite the Supreme Court of India having held that there was no justification under the law as it stood then to impose a tax levy through a retrospective amendment, we have been unfairly singled out and targeted. And Vodafone succeeded in that case against the Republic of India on the principle that there was no fair and equitable treatment that had been given. Now, if you come back and bring that principle back to how the Indian Supreme Court has looked at judicial review of administrative action in the trade and commerce field, again, as you see, it works towards freedom and fairness. And that is why it's extremely important to remember that our Constitution protects that freedom and allows for an absolutely fair play for the purposes of growth of trade and commerce, and that is what the Indian Supreme Court has recognized through the years, historically, till now, and will hopefully continue to recognize it in the future. So ladies and gentlemen, thank you very much for attending today's lecture. I hope you've enjoyed it as much as I have enjoyed preparing this lecture. So I'm very grateful again for getting the opportunity of spending some time with you. Thank you.
Thank you very much, Nakulji. So nicely you synchronized commerce and constitution and various judgments. Very interesting. It's a new area we discussed and thought-provoking and in the interest of the country also overall. Now I request Mallika will give you a vote of thanks. Then after that, question answers.
Good evening, everyone. It is my privilege to extend the vote of thanks for today's session. I would like to express my deepest gratitude to Senior Advocate and King's Counsel Nakul Dewan Sir for taking out time from his busy schedule and enlighten us on the topic of propelling trade and commerce through the Constitution. As they say, that we must understand history to understand our present. Thank you so much, sir, for taking us that how the economic unity of the country plays a important role in its cultural and political progress, and the principle stood the test of time as from 1961 till today. Also, it is an important, as sir started with, that it is not a commercial document. Constitution is a grand norm. It's not a commercial document, but it still has provisions for trade and commerce, for freedom of trade and commerce. And as he concluded, he talked about freedom subject to fairness. We can say it's a beautiful amalgamation of a commercial and a social piece of legislation, which was well thought out by our framers of a constitution at that point in time. I will not take much time because I'm sure many will be wanting to ask so many questions from sir. So I would just like to end with saying that thank you, that I cannot end this vote of thanks without thanking G.Seshagiri sir for his meticulous planning, dedication and timeless efforts as the backbone of this Friday group. Thank you so much, sir.
Thank you. Thank you, Mallika. Any question answers? Yeah, please.
I was hoping, now it's shut off. No? I was hoping no, but anyway.